Joining us now is Paul Tuchmann, a former federal prosecutor and current partner at Wiggin and Dana, as well as Zack Shapiro, managing partner at the crypto-focused law firm Reigns. Thank you both very much for joining us.
Thank you, and good afternoon.
Thanks so much for having me again.
So, Paul, you're a former federal prosecutor with experience prosecuting and defending fraud investigations here in New York. You served as an assistant U.S. attorney for the U.S. Attorney's Office for the Eastern District of New York for more than a decade. So, given your experience, I want to start off by asking, what do you think about Sam Bankman-Fried's sentence? Were you expecting 25 years? His lawyers were seeking a sentence of 5 to 6.5 years. Prosecutors were seeking 40 to 50 years. So are you surprised that Judge Kaplan sentenced Bankman-Fried to 25 years in prison, given that represents a pretty significant departure from what prosecutors were seeking?
Yes, frankly, I am a little bit surprised based upon the demeanor and the rulings that Judge Kaplan made during the trial, as well as the arguments the prosecutors made, that Judge Kaplan, both during the trial, but then also during the sentencing proceeding today, generally agreed with the prosecutors on in terms of the nature of the seriousness of SBF's conduct, the loss amount, the fact that he perjured himself, Judge Kaplan found during the course of his testimony at trial. In light of all of those findings that Judge Kaplan made, I frankly found it a little surprising that the sentence was not a bit, at least a bit higher. Certainly not necessarily the 40 to 50 years that the prosecutors were seeking, but 25 years was on the low end of what I was expecting going into the sentencing hearing today. And then particularly, as I said, after Judge Kaplan reached those findings about the perjury and about the loss amount.
So, Paul, expanding on that, today Bankman-Fried took the stand and had a remorseful tone, quite the contrast from his testimony during his trial. Bankman-Fried claimed responsibility for the collapse of FTX and said he was sorry that customers were deprived of their crypto gains. So do you think those comments on the stand today played into his sentence at all? It's important to note, though, that this morning, Judge Kaplan increased the sentencing guidelines range for Bankman-Fried to a maximum possible sentence of 110 years after finding that he had committed perjury at his trial and knowingly obstructed justice. So it sounded from the get-go that he wasn't going to be lenient.
It did sound that way. And I don't think that the statements that Bankman-Fried made during his sentencing necessarily were part of the reason why he got what I would expect, a lower sentence than I expected to see him get. Certainly, on the one hand, he did express, I don't know if I would want to call it remorse, but he did express regret and sort of sadness for his colleagues at FTX, as well as to the investors, or not so much the investors, but the depositors who lost money. Certainly, he said that he was sad that they lost money, and in some way, it seemed that he acknowledged some kind of responsibility for the fact that they did lose money. But at the same time, importantly, because he has an appeal pending, and therefore anything he says today that indicates that he actually agrees that he did commit a crime, he's continuing to maintain his innocence through the appeal process. And if he was to win an appeal, any admissions that he makes in the course of the sentencing proceeding could be used against him at a future trial. And so for that reason, he didn't fully, I would say, and I think Judge Kaplan agreed in the remarks that I saw quoted, didn't really agree that or believe that SBF had truly been remorseful. And in fact, one of the things that Judge Kaplan said when imposing sentence was that he had a real concern that Bankman-Fried, whatever he concluded his sentence, was in fact a danger to commit another crime like this in the future. And certainly if the statements that SBF made at sentencing to the judge, certainly if those had been successful in the goal of truly showing remorse, that I certainly don't think Judge Kaplan would have reached that conclusion during the sentencing hearing today.
So, Zach, what's your reaction to Bankman-Fried's sentence? Today, Judge Kaplan rejected SBF's argument that there was no loss at FTX, calling the claim misleading, logically flawed, and speculative. Based on everything that happened in the courtroom today, were you expecting 25 years? And do you think the victims will think this sentence is appropriate and fair?
Yeah, thanks. I think 25 years is pretty close to what I would have expected. I would have maybe even expected a little bit lower. The way federal sentencing works in criminal cases is judges have to start by calculating a guidelines-based sentence using an elaborate formula. Those guidelines used to be mandatory in terms of what judges had to sentence people for. Now it's just a starting point. But when you deal with crimes that have big numbers involved, whether that's a large quantity of drugs or in this case a large amount of money that's gone missing, the end output of those guidelines tends to be a really large number. And so it's not surprising the judge would do a downward departure from the guidelines calculation. And that really puts the sentence into a question of what would the judge, Judge Kaplan in this case, think is fair. And we're talking about a white collar crime here, right? A bad white collar crime, a really big white collar crime, a brazen one. But if you look at murder sentences in gang trials in the Southern District of New York, those are often in the 20 to 25 year range. And so I'm not surprised that Sam Bankman-Fried didn't get a 40 or 50 year sentence. I do think that his and his lawyer's performance today were pretty bad. His lawyer, Mark Buchesi, really painted him as sort of a hero of some sort, called him a beautiful puzzle, pointed out his veganism, called him, he read like a Talmudic scholar. And I think that really maybe missed the point in terms of how much damage he caused. Of course, there were losses. The fact that the FTX made some lucky venture investments that were able to make creditors whole as of the bankruptcy, notably not in crypto terms, but in the bankruptcy terms, I don't think absolved him of any of the crimes. The fact that he seems to have perjured himself on the stand also certainly didn't help. And the fact that when Sam testified himself today, he was more focused on the facts of what happened than showing contrition to the victims, I think also didn't help. So I think 25 years is a harsh sentence. I think it was in the expected range, but I think that this is just. And what I hope is, I think a lot of the crypto community was skeptical of what sentence he would get. They thought he might get an unreasonably low, maybe below 10-year sentence, and that justice wouldn't be done. And there were frankly a lot of conspiracy theories about that. And I think that it's good to show the crypto community that justice does work, at least in this case.
You are, in fact, a crypto-focused attorney. So in what ways do you see this case being a template for the crypto space at large? U.S. Attorney Damian Williams issued a statement saying that today's sentence sends an important message to others who might be tempted to engage in financial crimes that consequences will be severe. Do you think that message will resonate with those thinking of defrauding crypto investors from here on out?
Yeah, I think so. Last time we spoke about this, I mentioned that I think this is really more a story about old school fraud than it is about crypto itself. I think there's one way in which that's not true, which is that the crypto community, I think, has to learn this lesson every couple of years, that the whole ideal behind crypto is creating open source, trustless systems where you can see, using a blockchain or similar tool, where funds are, what the mechanisms are to secure funds, and who has permissions to move those funds. And that obviously doesn't work when you just trust a third party, in this case, FTX. But there are other examples, famously Mt. Gox in the early days of crypto, one of the early Bitcoin exchanges. When you trust someone with your crypto assets, they can move it, right? And we're talking about digital bearer instruments that are easily stolen. So I think, insofar as this is an important lesson to the broader crypto community, maybe it's less towards the people who would commit fraud. I mean, I think this is no different than any other large criminal case in that respect. But for crypto investors, the people who are the depositors who lost money in this case, to really think about who do you trust, who, if anyone, do you trust your cryptocurrency with? Is it better to self-custody or use a collaborative custody model for cryptocurrency, or to use sort of more "quote unquote" trustless, tools on the blockchain to hold your digital assets?
So, Paul, what happens next? You touched on this, but SBF is expected to appeal today's decision. What do you think will happen with that appeal, and what steps are involved?
Well, the next step actually is that within the next couple of months, presumably, SBF, who has been living at the Metropolitan Detention Center in Brooklyn ever since he was remanded after the judge found that he violated the terms of his bond before the trial, he's going to be designated to a federal detention facility somewhere in the United States. And Judge Kaplan recommended today that he go to a medium security facility or something less secure than that. Doesn't seem to have concerns about SBF, engaging in violence or in trying to escape. As one may have heard, there are federal prison camps in the federal prison system, which are known as Club Fed. And those are sort of the most desirable, of course, places for federal inmates. However, it doesn't look like that SBF is going to be eligible to serve his sentence there, at least not for a bit, because generally the rule is that you can't serve your time there until you have 10 years or less remaining on your sentence. So instead, he's going to go to something closer to a real prison, whether it's medium security or at least low security. In the meantime, his lawyers are going to put together an appeal. On the one hand, there was an overwhelming amount of evidence. I think most observers agree that was introduced by the government at the trial that will make it quite difficult to show that there was an insufficient amount of evidence to convict. And similarly, the theories that the government prosecuted the case on were not particularly novel or cutting edge. It was actually, despite the large amount of losses and the extent of the fraud, a relatively simple case. And so I don't think there's too much concern about legal issues. I think the main concern or the main likely to be the main avenue of appeal, or the main arguments on appeal, will be that Judge Kaplan ruled before trial that Bankman-Fried could not put on a number of aspects of the defense that he wanted to mount in terms of calling certain kinds of expert witnesses, in terms of certain things he wanted to testify about himself, with respect to various aspects of, for example, the terms of service that FTX had. And so there were certain things, if he wanted to, and he made motions about being able to mount in his defense, and the Judge Kaplan denied that. So I think that's likely to be the biggest point that they'll raise. In the meantime, one other thing that I wanted to mention when we talk about the sentence is that, in fact, while 25 years certainly is a long time, SBF starts out like all federal inmates with a 15% good time credit, which he could lose if he does not engage in good behavior while he's in prison. But even if you give him that 15% time off for good behavior, you get down to around a little more than 21 years. And then with the Federal First Step Act, which was enacted in 2018, white-collar defendants and convicts like him have the opportunity to earn significantly more good time credit, certainly at least another year, perhaps off his sentence, than a significant amount where he could actually serve a significant number of years of his sentence on home confinement. So I think that's another thing just to keep in mind when we think about the severity of the sentence. 25 years is a long time, but it is certainly possible that a good chunk of that sentence will be served at home.
And Zack, how has crypto sentiment changed in terms of legal compliance since a jury found Bankman-Fried guilty of all 7 criminal counts against him back in November? Have you noticed that crypto companies have been working to be more compliant since then?
Look, I think most crypto companies were not in danger of violating the law in the same way that Sam Bankman-Fried and FTX did, right? That I think is just an outright fraud. The 2 major regulatory issues in crypto right now that companies are working their best to comply with, the biggest one is around securities law compliance and the offer and sale of tokens, either a primary sale from issuers or a secondary sale on exchanges like Coinbase and Binance. Do those constitute investment contracts or securities offerings in a way that gives the SEC jurisdiction? And there are 3 major civil cases going on right now directly about that question, in addition to the Ripple case. That is the 800-pound gorilla in the room of crypto. And I think, certainly all of my clients, and I think most crypto companies out there, really would love to comply with the securities laws insofar as that's possible. I think, unfortunately, the SEC is a little bit playing hide the ball with where the contours of what an investment contract is or isn't in the case of digital assets. So certainly companies are trying to comply, but they're also trying to get wins in court. And I think with the Ripple decision, and we'll see what happens in the Coinbase case, but maybe they will get some of that clarity from federal courts they're not getting from the SEC. And then there's also efforts, of course, on the lobbying front and the policy front to get new laws passed that create, I think, more rational rules that apply to digital assets. The other main question is, where is the line between peer-to-peer code, right, and a decentralized exchange where it is 2 people exchanging assets, one between another, using code as an intermediary, and a financial institution, right? At what point does a decentralized exchange, does a protocol get regulated like a company? And that's, I think, a really gray area. The technology that those rules would apply to is constantly changing. We got one nice ruling yesterday in the Coinbase case where the SEC's claim that Coinbase was acting as a brokerage through its wallet, which essentially was just a front end that allowed users to access decentralized exchanges and DeFi protocols. That was dismissed by the court. I think that's a great sign about where we might be headed on DeFi regulation. But I think regulation in the crypto space and compliance in the crypto space is really much more about these questions, the sort of money service business versus peer-to-peer protocol, and the, is a token a commodity or an investment contract security. That's much more where the action is than, are people going to perpetuate the type of massive fraud we saw Sam Bankman-Fried do.
Zack Shapiro and Paul Tuchmann, thank you both very much for joining us.
Thank you.
Anytime.